Welcome. On behalf of the Wisconsin Institute for Public Policy and Service and the UW-Marathon County campus, I'd like to welcome you for the panel discussion that we'll be holding tonight, The Constitution, Congress, and the Presidency, What are the Limits of Power? This event is part of the WIPPS Public Issues Series. My name is Eric Giordano, and I'm the director of WIPPS. WIPPS is a unit of the UW Colleges and UW Extension and was founded in 2007 here in Wausau. Our mission is to address local, state, and national issues by linking public scholarship, civic outreach, and student service to enhance community life throughout Wisconsin. We believe that the strength of American democracy in the 21st century depends on the engagement of citizens and communities in making decisions about issues that matter to us. To this end, WIPPS's task is to provide resources, information, and ideas to empower the people and communities of Wisconsin. Now, tonight's program would not have been possible without the hard work of an entire core of people, most of which you will not see tonight, particularly our program manager who could not be here, Julie Bunchak, our development director, Aaron Zitzelsberger, our marketing director, Deb Dorhorst, and several WIPPS interns, which you'll see outside of the room and when we have our Q&A. We're grateful to technical support from our theater technician, Chris Berg. And we want to acknowledge that this Public Issues Series is made possible through the support of the Merco Foundation, Dean and C. Ann Dietrich, and Kevin and Wendy Hermaning. Misters Dietrich and Hermaning are Wausau businessmen who are committed to open, nonpartisan dialogue. And we're so grateful that they are willing to support this. In fact, Dean Dietrich is here, so thank you, Dean, so much for your support. We appreciate that. We are also especially grateful to be co-presenting this event with the Wisconsin Academy of Sciences, Arts, and Letters, which is based in Madison. They've been a great partner on this project and on other projects, and they're certainly interested in having you understand their mission and the role that they play in our state, and they have a table with some material outside of the theater for you to take a look at. And now we'd like to welcome you to our event, The Constitution, Congress, and the Presidency. What are the limits of institutional power? This event is being covered by Wisconsin-Eye, Wisconsin State Public Affairs News Channel. It is being streamed at wisci.org and will also be archived on that website. Tonight's moderator from Wisconsin-Eye is John Laabs. John began his career as a news reporter right here at WAOW TV in Wausau. This was followed by 16 years in government service and government advocacy. In 1988, he became president of the Wisconsin Broadcasters Association. During his 19-year tenure there, the WBA grew greatly. Chief among his accomplishments are the creation of the Wisconsin Amber Alert Program, the Broadcasters EEO Compliance Program, and the Wisconsin Broadcasting Museum. He also was the founding president and CEO of the Wisconsin Broadcasters Association Foundation and founding member of the board of directors of Wisconsin-Eye and a member of the Wisconsin Broadcasters Hall of Fame. And most important of all, he attended UWMC as an undergraduate and was awarded the John S. Newberry Award for Creativity. Please welcome John Laabs.
Thank you, Eric. I'm prepared for my first performance at UWMC in 40-plus years. Eric's given us all the title for this evening's discussion: Congress, the Presidency, and exploring the limits on their institutional powers. That all suggests a tension between these branches of government, and that tension has its foundation in the U.S. Constitution, which was written in such a way that each one would balance and check one another. Now, most U.S. citizens generally understand that the legislative branch makes policy by its enactments, and the president executes or implements that policy, often using administrative rules and executive orders. But that generality has become somewhat blurred with the political evolutions of the 20th and 21st centuries. And that's where we start tonight. Our panel will try to provide a constitutional context for the tension between the legislative and executive branches, an historical look at congressional and presidential interactions, and how the passage of time, national growth, and government expansion have affected those interactions. We'll spend a good deal of time on the use of the executive order and how its use has changed the governance over the last 60 to 75 years in the United States. Along the way, our panel will discuss the limits on each institution's powers and how those limits are exercised or not. And promising not to solve anything tonight, we'll leave a half hour for your questions and comments. Our plan is to approach our topic in an informal discussion mode. With that, let me introduce our panelists. First, on my immediate left, Karen Hoffman is a visiting assistant professor of political science and associate director of the Les Aspin Center for Government at Marquette University. Her research interests include political communications and political institutions, including presidential rhetoric and media studies. Her recent work has focused on the changing dynamics of rhetoric and public opinion prompted by the digital revolution. She has an MA and a PhD from the University of Chicago. In the middle is Barry Burden, a professor of political science, director of the Elections Research Center, and the Lyons Family Chair in Electoral Politics at the University of Wisconsin-Madison. His research and teaching focus on U.S. elections, public opinion, representation, and the U.S. Congress. His recent research has centered on aspects of election administration and voter participation. He earned his PhD from Ohio State University and was a faculty member at Harvard University before coming to Wisconsin. And on my extreme left, Eric Kasper is an associate professor of political science and director of the Center for Constitutional Studies at the UW-Eau Claire. His teaching focuses on constitutional law, judicial politics, and political philosophy and jurisprudence. He is particularly interested in the intersection of politics and pop culture. He has an MA, a JD, and a PhD from the UW-Madison. With that, let us begin. Congress, the presidency, their institutional powers, and their limits. Let me ask Eric Kasper to begin the discussion, providing some constitutional context. Eric?
All right, thank you, John, and thanks to WIPPS for having us here this evening. When we start out thinking about the Constitution, I mean, it's always a good place to start. It's kind of a user manual. It's got the rules to the game, so to speak. And there are things with respect to, so it's kind of common knowledge what the Constitution sets up in terms of the system of separation of powers and checks and balances. And so what I want to do, though, here in my opening remarks is just to get into a little bit more detail about what the Constitution says in particular about these things, and then talk about some of the cases that have arisen over the years, kind of trying to figure out where the lines are between congressional power and presidential power. And that will necessarily involve me talking about the third branch of government, the courts, and what they have said. If we look kind of at the outset, Article 1 of the Constitution is the article that is primarily about Congress. Article 2 is the article of the Constitution that's primarily about the presidency. And each one of those articles begins by respectively talking about, in Article 1, how the legislative power, again, whatever that is vested in Congress, and how executive power, whatever that is vested in the president. And then from there, these articles get into more specifics in terms of what's at stake. Things like in Article 1, talking about how Congress has the power to pass bills, but the president has this veto authority. And the president may make treaties and appoint ambassadors and other principal officers, but that is to be done by and with the consent of the Senate. And so you can look to a number of places within that document and see examples of that checking and balancing, as many people are familiar with. One area that we'll probably get into a little bit more as we go on this evening will be the provision in Article 2 that talks about how the President shall take care that the laws be faithfully executed, which involves a number of things, including arguably where the executive, the power to issue executive orders comes from. But before I dive more specifically into some of these powers, let's talk about the ability of these two branches to check each other, and in particular, what happens if presidents behave badly. Because that is in and of itself an area where Congress can check the president. The impeachment power, the removal power that the House and the Senate have in that regard. And so that is another area to consider here in terms of where the limits of power are. It is to be done for treason, bribery, or other high crimes and misdemeanors. Again, what that term means is probably best defined as whatever a majority of the members of the House of Representatives thinks it means. And so there is definitely that political power that can be exercised by the Congress, first by the House and then by the Senate if necessary, if the President is transgressing whatever limits there are there that the President or that the Congress thinks the President has gone too far. There's also, when we look at succession, of course, everyone is pretty familiar with the fact that the original Constitution as well as the 25th Amendment talk about what happens if the President dies, for instance, and the Vice President takes over. But there are some other interesting aspects there where Congress has a role to play. One is if there is this question about whether or not the President can discharge the duties of office. And if the Vice President and majority of the Cabinet believe that the President is unable to discharge the duties of office, and the President disagrees with that assessment, then the question goes to Congress, and Congress makes that decision about how to resolve the question. Likewise, interestingly enough, the Succession Act of 1947, where Congress exercised its power under the Constitution to provide by law what should happen in the case of removal, death, or resignation or inability of both the President and the Vice President. It's interesting that the first two people in the line of succession after the Vice President are members of Congress, right? The House Speaker as well as the President pro tem of the Senate. And so that is potentially another area where Congress has exercised its authority to be able to maybe push the boundaries of where it is as an institution and what its members might do in the case of that unfortunate set of events. And even under the original Constitution, considering presidential selection. Of course, as we've all been made well aware in both the most recent election and in 2000, it doesn't matter how many popular votes you receive. What matters is who wins the Electoral College in terms of the presidency. But one interesting aspect of that process that hasn't been invoked too often is what happens if no one has a majority of Electoral College votes. And in that instance, what would happen is amongst the top three vote getters under the current requirements of the 12th Amendment, their top three vote getters for the presidency in the Electoral College, their names would be brought to the House of Representatives, and the House would make a decision about who it is who should be elected president. And the Senate would do the same thing with respect to the top two vote getters for vice president if, again, no one has an Electoral College majority. And so right at the outset, before we get to the more specific areas of power, you can see when it comes to presidential selection, presidential removal, that there are roles that Congress has in terms of not only policing what the president may or may not do, but also potentially having a hand in who the president will be. Now, if we look more specifically to the different powers that each of these two branches might exercise to keep the other in check, there are some interesting places where we could look. One would be Congress's power to investigate. The power that Congress has in order to hold hearings for a variety of reasons, including if they think that there is something that is not quite right in the executive branch. And the U.S. Supreme Court has long held that that is, at the very least, an implied power of Congress, a power that they have in order to fulfill their constitutional responsibilities, something not spelled out anywhere specifically in the text, but a power that Congress has related to something called the Necessary and Proper Clause. It's at the end of Article 1, Section 8, and it tells us that Congress shall have the power to do things that are necessary and proper in order to put into effect all of its specified enumerated powers under the Constitution. And the Supreme Court has held that Congress has that authority to investigate on any subjects in which Congress could validly legislate, as long as it does not invade areas constitutionally reserved to the courts or to the executive branch. And so again, if Congress is fulfilling its responsibilities, including not just following up in terms of the way that funds are spent in the executive branch or administrative agencies and what they're doing, but potentially to the highest levels in terms of investigating what's going on in the White House and things that might lead to impeachment, that power all stems from Congress's implied powers under the Constitution to engage in that investigation. Looking more specifically at, on the other side of the House, the powers of the President, in a case dating back to 1890 called In re Nagel, the Supreme Court began holding that the President has the power to act, even to enforce the law, when there is not a law passed by Congress to enforce. In other words, going back to the executive authority that exists within the executive branch, in that vesting clause at the beginning of Article 2, and in the President's power to take care that the laws are to be enforced. Those lead the President to this power in order to take action to do things that executives do, even if there isn't some sort of specific congressional authorization. When looking at questions of appointment and removal of executive branch officials, while cases have for many years held that the President has the power clearly to make appointments, and there's no question under the Constitution that's a specified power of the President when it comes to principal officers. There's this open question under the Constitution, well, what about removal? What if the President doesn't think someone is doing their job? Can the President simply remove that person from the position, particularly if that position required Senate confirmation? Does there have to be some sort of negotiation with the Senate in that regard? And here, to show the line of where executive power ends, perhaps, and where legislative power begins, Supreme Court for close to a century has held that if it's truly an executive office that's carrying out executive functions, then the President does have that sole removal authority, can say, that's it, you're fired, you're gone. And that's a power that the President can exercise because if the President's to do the job effectively, you need to make sure that the people are carrying out the will of the President. On the other hand, if it is the case that executive branch official is carrying out any type of quasi-legislative or quasi-judicial functions, then the Supreme Court has held that Congress can put limits on the President's removal power. And the Congress can say that you can only remove someone for cause or for certain reasons in some of these executive branch agencies, for instance. And so again, that's another area where the courts have said there's a role for Congress to play to check what the President might do, depending on the type of power being exercised. In a more perhaps direct question of Congress and the President working together, the courts have for many years held that as long as Congress lays down what the courts call intelligible principles, and if Congress is specific, Congress can delegate power to the President, including the power to make rules, and Congress can delegate that power to others in the executive branch as well. And so that type of sharing of power, if Congress believes it to be appropriate, is an area in which the Supreme Court has said Congress can engage in that as well. Now, when it comes to Congress trying to take power, however, the courts have policed that line a little more closely. And so, for instance, something like a legislative veto, that if Congress, for instance, were to delegate some sort of authority to the executive branch, but then say, well, we're going to watch what you do, and if you exercise that power in a way that we don't like, we might pass a one-house veto of that. within the Congress. There, the Supreme Court has said that that is a violation of the Constitution, that if Congress wants to delegate some authority away, they're free to do that. If they want to go through the normal channels of passing a new law, they can take that power away as well. But what Congress cannot do is allow itself just one house, the House or the Senate, to veto that executive action. And they can't do it without also presenting that new law to the president for signature or veto. So again, some areas of policing there as well. And then finally, a major area when it comes to these two branches, Congress and the President, is what about war power? A lot of people think about war power, and the first thing that they'll think of is that the Constitution gives the President the power to be Commander-in-Chief. And it certainly does. And related to war power, more broadly foreign affairs power, because the President has the authority to negotiate treaties, the President has the appointment power over those who will be foreign ambassadors, and because the President has the specific constitutional duty of receiving foreign ambassadors. The presidency tends to be looked at quite very much so by many Americans as the place where the power over war and foreign affairs is placed. And the Supreme Court, in some of its decisions, has even made note of the fact that because the executive branch is set up so the president is one person at the top of that branch, that one person can then act quickly in an emergency situation. And that's something not to be forgotten. Congress, insert your Congress joke here, they're slow, they're deliberative, right? They don't always get things done as quickly as we want to, although to be fair to them, that's the way the institution was designed. But in an emergency situation, you need quick action. There is sometimes a deference that is given to the president for that reason. However, it's not to be forgotten that under the Constitution, Congress has a tremendous role to play when it comes to war, when it comes to foreign affairs. Congress, of course, is the branch that has the power to decide whether or not we will officially declare war. Congress has the specified powers of raising and supporting armies, the power to provide and maintain a navy, the power to regulate the military more generally, the power to call forth the militia if necessary, although that particular provision may not be as relevant as some of the others in our modern day U.S. here. And the Senate, as we've alluded to before, also has that power when it comes to deciding whether or not to ratify a treaty that the president has negotiated. The power whether or not to confirm those who will be appointed to some of these positions, where they will be engaged in exercising foreign affairs for the United States. And so there's certainly quite a role to play there on the congressional side when we look at war and foreign affairs. And the Supreme Court has most notably recognized that fact, going back to a very famous case of Youngstown versus Sawyer, a case from the early 1950s, where there was a question about, at that time, President Truman ordering steel mills to be seized. Because there was a threat of a strike, and there was a question if the steel mills were shut down because of the strike, that the U.S. would not be able to have as much production for tanks and for weaponry and so forth to use in the war. And the Supreme Court said that under those circumstances, that was unconstitutional for the president to engage in the taking over of private industry in that regard, given where the theater of war was, what the state of the war was. And in particular, one of the things that was noted in a concurring opinion in that case, written by Justice Robert Jackson, is he put in place a framework that the Supreme Court has now, in a modified form, adopted when understanding this power amongst these three branches when you get into war and foreign affairs, which is that if the president is acting with the expressed will of Congress, then you have those two branches working in concert with one another, and the president's power to take action is at its highest. If the president is acting in the face of congressional silence, then what Jackson described this as is, then we're in a zone of twilight. Then the president has the president's Article 2 powers to certainly fall back on, but the president isn't acting with Congress behind the president, and so that means the president has a little less authority. And then finally, Jackson described a third category when it comes to these situations, which is if the president is acting against the express will of Congress. Then, as he put it, the power of the president is at its lowest ebb. And that is a situation whereby you have these two branches opposing each other. And that's, again, where we're coming back to these first principles. Congress checking the president, Congress saying that we don't believe that that action is necessary or warranted. And the court signaled, beginning in that case in a concurring opinion, but later in majority opinions, that if that is the case, then the court itself wouldn't come down in favor of that presidential power being viewed very broadly or very substantively. And then perhaps the last thing that I'll add before I turn it over, one other area that's not to be forgotten is the Bill of Rights and what exists there in terms of limits on the powers of either Congress or the president. And that's probably something we'll get into in more detail as we go along. But that is, again, another area where the Supreme Court has come in and said that that becomes a different type of limit than what we see this battle between Article 1 with Congress and Article 2 with the president. But another area in which the courts have said that these are strong, hard limits on what either Congress or the president can do if they are encroaching onto any rights that are protected by the Bill of Rights.
We thought it important to start with that kind of a base for everybody, but now we're going to get into some juicy stuff. Let's talk about the interactions between the executive and the legislative branches historically. You can start with George Washington if you want.
That's
Karen?
generally where I start. So I'm interested in looking at institutions as they develop. So I've spent quite some time digging into the practice of early presidents and how the Constitution was viewed in those days. And I think while I'm not going to try to claim that anything that happened back in these early days is the equivalent of what we're seeing now, I do think that we can see clues and hints in the past that explain sort of how we got where we are. And I think the first thing to say, just to add a little bit in terms of the Constitution, it is remarkable how little Article 2 actually tells us about what the president is supposed to do. And it's interesting, I always tease my students that I said it would be really handy if the Founding Fathers had created a glossary for the Constitution. Because, Eric mentioned the executive power. What on earth is included in the executive power? Well, we're still figuring that out. And we have presidents in the last few cycles who have had very interesting things to say about what the executive power is. As a matter of fact, the Founding Fathers, mostly in terms of the president, talked about whether there should be one or more presidents, executives, how long the presidents should be in office, and who should select the presidents. They spent very little time talking about what the president actually might do. So here we enter George Washington. Here he is inhabiting a brand new institution. There's not a very good, he does have Article 2 to go by, but I don't know if you've looked at that recently, it's very short. There's not a lot there to go on. And I find it very interesting that not only for George Washington, but some of the subsequent presidents, what you see is the vague wording of Article 2 actually lends itself to some sort of liberal interpretation of powers. And I'll give you one example from George Washington, who, by the way, here is the father of our country, this beloved person. Actually, in our society, he's not even really a human being anymore. He's sort of this mythical character. But he wasn't, he was very much admired at that time, but when I tell this story, people actually talked about impeaching George Washington. So this is the extent to which there was already disagreement about what the Constitution meant. So France helped the United States during our revolution. We had a treaty with France, a couple of treaties with France. And, we became a country, they helped us win, and here we were on our merry way. And France and Britain started a war with each other. And we didn't know what, George Washington was trying to figure out, well, what do we do? he didn't think that we were prepared to be in a war with great powers. He thought we were too weak. So he decided, after asking his cabinet members what they thought, to declare that the United States was neutral in this conflict. And there was really no precedent for what to do in this kind of situation. But a lot of his opponents said that that was unconstitutional because we had a treaty with France that presupposed certain commitments to France, and that what in the world was the president doing anyway, weighing in on whether we were in a state of peace or war, because Congress had the power to declare war. So there was this whole tempest in a teapot, very partisan, as things even were back then. Mostly the Anti-Federalists thought that he was, acting unconstitutionally, whereas the Federalists thought that he was doing the right thing. But I want to read you just a short passage from an editorial in a newspaper of the time. And keep in mind that when I'm referring to the president, we're talking about George Washington. So it said, "The opinion that the president ought to be impeached is gaining proselytes daily and will soon become general as the subject is more fully understood. The revolution was certainly never designed to benefit the president alone, and if he can exercise unconstitutional and unlawful powers because he was the commander-in-chief of the American army, then the revolution was designed for his aggrandizement only." And I mean, this is our beloved George Washington. Now, as it happened, in the long term, people thought it was actually probably a good thing that we didn't get involved in this war. So it sort of blew over because they thought, well, actually, he probably saved us from a huge mistake. But even James Madison was opposed to what George Washington did. He said that the right to choose between war and peace was vested in the legislature by the Constitution, and it was not the president that got to make that call. So already, I think in the very beginning, you can see that there's a certain area of, twilight, I'll use the word, that, presidents have operated in. And I think you can go down the line, and I think I would be hard-pressed to find a president where you couldn't find an example where someone thought the president was pushing too far and Congress was upset, or, as Eric mentioned too, sometimes Congress did not sort of step up to claim its authority. Just very briefly, one other, Andrew Jackson, I'm sure many of you are not surprised that he's high on the list, was very much thought he was a direct representative of the people and was not terribly concerned with all of the checks and balances between the powers. But one of the interesting things he did was he did exercise the veto, which wasn't done a whole lot yet at that time. He particularly did not like this thing called the National Bank, and so he vetoed the law that was going to it had run out and was going to start the National Bank again. But what he did after that was, even though Congress had said that the situation where the money was okay, is Andrew Jackson, on his own unilateral action, took all the money, or directed that all the money be taken out of the national banks and put into various state banks, which, I mean, people were in fact, he was formally censured by Congress during this particular time period. So we have been struggling with the limits and what presidents are allowed to do and what Congress's responsibilities are for the longest time. And I know that our sense of history isn't always the greatest, so maybe we forget that. But I don't want to talk too much longer, but I do think there are four sort of lessons that I take away from the study of some history and the president. And one is that when there's an absence of agreement on what vague phrases mean, I think the advantage goes to the president. The president can act quickly, as already mentioned. You don't have to get a whole bunch of people together. So I think that does advantage the presidents. And so they have been able to reach fairly broadly sometimes. Also, presidential unilateral action, whatever it was more likely to be supported constitutionally if it was popular. Now, no great surprise there. So George Washington was actually a pretty popular guy. So I think that people were pretty quick to say, oh, well, you know, George Washington did this, it's probably okay. Or if they really liked what they were doing. You know, I'm sure you all remember after 9/11, the vote to create the Patriot Act, and also the authorization of the use of military force for the president was very wide. There was a lot of support for that, although in hindsight, maybe some people regret that. But at the time, very popular. Second, or I guess third, times of crisis are often when the powers get expanded, because people are afraid. They do not look to a group of, or two groups of 535 people collectively to try to act quickly to say, you know, to protect the country. And once a power, and then this is the fourth thing, once a power is taken, very rarely do subsequent presidents completely give it back. In a sense, you can't unring the bell. And I think what you've seen then, starting from the very beginning, is, you know, various actions taken by presidents that are sometimes very popular, but then once they're used, other presidents feel like they can use them as well, and then we become accustomed to them. And I'd like to stop there and listen to some other things that happened later in our history.
Can I just amplify that point? I think if the founders were here today, they would not recognize the government that exists. They would be surprised by its size and complexity and the role it has in foreign affairs. But I think they would also be surprised by how much power has flowed to the presidency away from the Congress. And this is to Karen's point about how easy it is to forget history. Our U.S. Constitution is actually the second Constitution. The first one was something called the Articles of Confederation, which was adopted during the American Revolution and governed the country for a decade. It looked very different from the Constitution we have today. It had no executive, there was no president, there was no council, there was no team of people leading the executive branch. It really was a one-branch government, which was a Congress made up of delegates from the states who would come to Washington or Philadelphia or wherever the capital was and vote as blocks representing their states. Now that was not an effective form of government, and I think we realized very quickly in the midst of a war against Britain that it wasn't sufficient, and it was difficult to even maintain domestic order. And so the Constitution was rewritten. But even the Constitution we live with today has all of these prohibitions and limits on what the presidency can do. It says very little about its explicit powers. I think the Constitution is about 8,000 words, and about half of it, 4,000 words, is in Article 1. It's about the legislative branch. This is the first branch of government. The president is the second branch of government, as Eric pointed out. And the Congress is given all of these enumerated powers. The Congress shall have the power to do all the things Eric mentioned: declare war, raise navies, collect revenue, build roads, establish post offices, impeach the president, and remove him from office. Whereas the president has 2 or 3 powers. I mean, there's almost nothing said there. And so I think the founders would be surprised at this shift down Pennsylvania Avenue. Note even that in the Bill of Rights, which is essentially a list of things the government cannot do to its people, most of those start, Congress shall not. They don't begin, the president shall not. The founders weren't really worried about the president so much because they didn't give him much authority, and it was George Washington whom they trusted. But they were concerned about the powerful branch, after all, the Congress having too much influence and encroaching on free speech, religious liberty, due process, privacy issues. And so you'll note that those Bill of Rights are really targeted at the Congress. And then there's this clause that Eric mentioned, the necessary and proper clause, saying essentially Congress can do what it needs to do to enact all of the other powers we've given it. And that clause has been, it's known as the elastic clause because it's been stretched over time to give Congress all kinds of authority. So the government we live with today really looks quite different, I think, from the one that was envisioned.
Got to make sure I'm on. How have things changed over time? And I want to try to bring us up to the present. There's been much talk, at least in the last 15 years, that we all can really remember about government by executive order, the executive really taking more power than ever before. But the roots of this go back. You cited some examples, and it's gotten worse, or more prolific is the best way to say it. I guess that was an editorial comment. We'll take that out. It's gotten more prolific since the 1970s. It probably started earlier, but
Yeah.
why don't you comment about the 1970s?
Yeah, I mean, from the beginning of the Republic, it's been something of an arms race between the executive branch and the legislative branch to build up their own strengths and try to combat what the other branch was doing. Some of that is building up their own infrastructure. So the Congress adds staff and committees and experts, and the presidency adds staff and experts and advisory commissions. And so they're both bulking up to try to defeat and have control over the other. And this really there have been several episodes where this has happened rapidly around, say, World War II, in the midst of the Depression, other times. But there was this period in the 70s, which I think is instructive for what we're living through today. In the early 1970s, when Richard Nixon was president, he was working with the Democratic Congress. They did not see eye to eye on a number of things. Nixon tried to use the powers of the presidency to do some things that presidents had not done in the past. You know about the Watergate scandal. But there were other things. In particular, there were funds that were appropriated by the Congress to be spent on particular purposes. And the Nixon administration decided they were not going to spend those funds. In some cases, they were going to impound them, simply sit on them and not spend the money that Congress had allocated. That seemed to run against what was in the Constitution, which gave Congress the power of the purse and told the president that his job was to make sure take care that the laws were faithfully enforced. And so Congress passed a law known as the Budget Act at the time, which tried to stop the president from impounding funds and also upped the arms race by giving Congress more authority. It created for itself the Congressional Budget Office, the CBO. It created budget committees. Paul Ryan was chair of that committee just a couple of years ago. This is the structure that's supposed to hold together the budget process. And it created a set of timelines and structures for passing a budget in an orderly fashion each year by the beginning of the fiscal year as a way to take control of that process from the executive branch. In addition, the Congress also passed something known as the War Powers Act to try to stop what the Nixon administration was doing in Cambodia and Laos and elsewhere as the Vietnam War was wrapping up. I think all of those structures have proven to be failures. The War Powers Act was supposed to stop presidents from sending troops into harm's way without giving Congress some notice and reports, kept the president from having troops in the field for more than 60 days without congressional approval. That has been ignored, mostly when what the president's doing is popular. If you're sending troops into Haiti or Kosovo or other places, either for humanitarian purposes or to rescue Americans who have been taken hostage, Congress mostly goes along with that. So there's a case where the Congress was trying to take some authority back and essentially gave it right back to the executive branch. And on the budget side, the creation of budget committees, a budget process, the CBO, that also has totally lost its authority. There's no sense that the Congress is following the budget process at all anymore. We almost never have a budget passed by the time the new fiscal year rolls around in October 1. Even Speaker Ryan, who said he wanted to return to what was called regular order, working through the appropriations process, that has not happened. And now the Congress is actually disregarding the advice of its own CBO, its agency, whose head it appoints and whose expertise it's supposed to rely on to combat the OMB and other offices in the presidency. So there's a sense that these kinds of efforts to combat one another are sometimes fruitless, but nonetheless the branches try.
I'm going to make a big leap here to just talk about executive orders for five or 10 minutes. Do we have government by executive order now? If you look at the list, we've had 14,000 executive orders, roughly, since the beginning of our time as a government. And the last 3 or 4 presidents are not at the top of the list. But the last 4 presidents really get big charges that they were governing by executive order.
I think partly we have to remember how the functions of the national government grew so dramatically over time. I mean, there were 4 cabinet departments when we first started out. The executive order, it's become this very pejorative term, an executive order, but it's part of the take care that the laws be faithfully executed if one is, if a president is thinking properly inside his sphere of power. I mean, sometimes in order to, there have to be some kind of rules that operate in the executive branch, and a lot of time the agencies make those rules, but I think it's always been appropriate, but look at all of the things that the national government does now. Every single agency, then you've got all of these, quasi regulatory arms. There are so many things. It's just actually overwhelming to even think of. I think it's important to distinguish what kind of executive orders to that. I mean, because I think it's hard to imagine a president functioning without some executive orders in this landscape. But there's executive orders, and then there are things that seem to be substitutes for legislation, I guess. And I think it's important to distinguish those kinds of things.
Yeah, a couple of comments there. I mean, one is that, if you live by the executive order, you can die by the executive order as well. And that, the next president can come in and rescind that, put in place a new one. And so there isn't the same level of permanency that's there as if it really is legislation that's been passed by Congress, because passing a new law is much more difficult for a lot of structural reasons than it is to simply change an executive order. And I think it does come down to this question of what kind of executive order are we talking about? And with executive orders that are not doing the sorts of things that we would see legislation doing, or that we would think is in that category, in my mind, there's a lot of similarity there to something like prosecutorial discretion within the Department of Justice, for instance, right? That the notion that just because a law has been violated doesn't mean that a prosecution is going to move forward. That in some ways these executive orders are like that. Okay, here's what the law is. Okay, let's lay out a plan for how that's going to be carried out, and that certainly fits within what we would think of as executive power. I think, again, not knowing exactly what that means because it never was really defined in the Constitution, but that probably fits that bill pretty well, I would argue.
I mean, I might put executive orders into a larger bundle of unilateral actions that the president takes. And presidents have taken advantage of that in part because Congress has created a vacuum where they have no other alternative if they want to get things done. I think you saw a lot of that at the end of the Obama administration, where he felt as though none of his initiatives were going to work through the Congress. And so he simply took action. Some of those were executive orders, but some of them were memos or policy decisions or recommendations or administrative rules. DACA, which was the Deferred Action for Childhood Arrivals plan for the so-called Dreamers, that was done not by executive order, but by a memorandum. That's now been largely undone by the Trump administration, so this is live by the sword, die by the sword. But I would say Trump in particular has escalated the use of executive orders. He's running at a higher rate on an annual basis, about twice as fast as both Obama and Bush had. And I think that's partly because Congress is dysfunctional and unable to take the lead on those policy issues, but also because Congress is sort of willing to let him do that. And he takes the blame if anything goes wrong. They're all Republicans, and so they're mostly getting policies that they like or approve of. But he takes the heat when it's unilateral, whereas if they had to work through the process, they'd be putting some of their own members to risk to have to vote for the legislation, which may not be popular or might not actually get signed into law.
Why is it just partisan politics? I mean, I understand the makeup of the legislature now and the makeup of the executive branch, but is it just partisan politics that stops Congress from checking the president on executive orders or proclamations, or there's also something called the
signing
statement.
The signing statement. I like this part of the law, I don't like that part of the law, I'm going to enforce this and not that, but I'll sign the bill. That's not a veto, because he doesn't have a partial veto, but that's what it amounts to. But in any case, is it just partisan politics?
I don't think it's not just that. Members of Congress just have a different responsibility and a different way that they are accountable to their constituents. So when the 2018 elections roll around next year, members of Congress will go back to their districts and brag to constituents about what they have done. They will also complain about what the Congress that they're part of has not done. And so they'll, as Richard Fenno pointed out years ago, members of Congress run for Congress by running against it, essentially by criticizing the institution they're part of. And that's easy to do because it's big and complicated and inefficient. The president doesn't have that luxury. When he's up for re-election, which will be in 2020, the president can say, the Congress has been difficult and not helped me in enacting some things. But it's not possible to run for re-election and say, I've done nothing. And so I think at some points the executive feels an obligation to take some action. With the Obama administration, it was DACA, it was minimum wage, it was not enforcing marijuana laws in some states, it was other things. And those were all imperfect. They were not as much as the administration would have liked to have gotten from legislation, but it was something. So I think that's partly what's going on. It's more than party politics.
It's probably also fair to say that since the Supreme Court has said that executive orders have the same impact as a law, Congress has to pass a law to overturn it, and the president can veto it, and if he vetoes it, it takes 2/3 to override. So the president, one man, can do an executive order, or a woman can do an executive order, but it takes 2/3 of Congress to override it.
Well, and I think
Basically.
I think you're giving Congress too much credit right now. You're assuming they could even pass something that the president can veto, which really, I mean, they can't. Very rarely. And they always say, you hear the expression, all politics is local. And I think that's part of the problem you're having in Congress now, because everyone's, why the Republicans are running the show right now. Why is it that they cannot, come together? Well, in their constituencies, there are, their districts, people want certain things, and no member of Congress, or very few, I suppose some of them do fall on their swords, but then we don't hear about them anymore because they're gone. They're not going to disregard what their own constituents want. And I think that they're getting, different members in different areas are getting a lot of different pressures. They're not, I think, going out of their way to be dysfunctional. I think that, some of them are in tough places with this right now.
Yeah, I mean, I could make a joke that it's, easier, or it's not very easy, I should say, to get that 2/3 vote in each house of Congress. I mean, it's these days it seems like you can't get 2/3 of each house to agree what color the sky is, right? It's there's a lot of partisanship, a lot of bickering, and so if it's either the president issuing executive order or even the delegation of power by Congress to the executive branch, it's easier to give it up than it is to get it back. Because of that, if they're delegating that power and the executive branch wants it, the president wants it, then you just need a majority in each house, in theory. But to get it back, you need that 2/3 vote. And so it's interesting that's, and I don't think that's, the real reason why we've seen more growth in the executive branch than the legislative branch, because I think it is going back to these issues of when there's a crisis and it's, the power is just developed. But even outside of crises, you have these sorts of kind of normal domestic affairs issues that get delegated, and then all of a sudden they're harder to get back. But there are some very good reasons why members of Congress would prefer to pass the buck, and not all bad ones either, right? It's not just so that they are not on the hook for a bad decision, but also because if it's delegated to someone in the executive branch who has expertise, how many parts per million are acceptable in terms of arsenic in drinking water, right? Do we want individual members of Congress to be making those decisions, voting on that, or do they want that passed on to an executive branch agency where people have studied those sorts of issues for their entire life? And so there's an argument to be made that type of delegation makes sense under the right conditions, but it is easier to give that power away than it is to give it back, or to get it back.
So at the end of the day, I don't want to sound too pessimistic, but are we left with the only check on one president's executive order is the next president overturning that order? Ronald Reagan did an executive order to forbid spending any federal money on abortion. Bill Clinton overturned it. We've seen President Trump overturn several of President Obama's initiatives. In the absence of Congress doing it for whatever reason, to please constituents, or because maybe it's appropriate, are we just left with that? The next president?
Well, I would argue that there's more to it. I mean, it depends on if this is really an egregious violation or not, right? I mean, there are certain things that Congress won't do anything about for various reasons, including if the president's party controls Congress, for instance. But if you have something that really goes outside of those boundaries, like that Youngstown decision, right? That was that type of executive action where the Supreme Court came in and said, no, that's unconstitutional. And of course, Congress has played that role as well. And so I think if you're, depending on what you're looking at, if it really is something that is significant and that runs counter to what Congress wants or what the court thinks is permissible, then that can happen. But yeah, I mean, that's not the norm. I guess we could say that.
Well, maybe I can raise one other thing. The courts are an interesting, to talk about the effect of, how much can the federal courts check the president? I think that's an interesting question. I'd be curious to hear what you think about this, because isn't it also the case that the courts have to be slightly careful in how far, I mean, the court has legitimacy because people respect it. It doesn't have a whole lot of enforcement authority. So, they have been known to sometimes perhaps not weigh in on something that, I don't know, that they would rather not. A political question, that's their big out, right?
Right, that is.
But how realistic is it that we can expect like signing statements? They have not weighed in on signing statements, to my knowledge, have they? The court has not.
No, and I think there is probably more of a standing issue than anything else. Who's brought a suit that has raised that question? And it's kind of difficult to do that,
right,
because of the practical effect. But nevertheless, right? It's.
Would they dare? What would happen though if a president ignored them? Isn't that really ultimately?
Well, that goes back to the apocryphal, perhaps, statement of Jackson about Chief Justice John Marshall. The Chief Justice has made his order. Now let's see him enforce it. If we really get to that point, then, and depending on what we're looking at, I think back to Nixon versus the United States, right? If President Nixon had ignored the Supreme Court's order to turn over the Watergate tapes. We're already on the road to Congress stepping in and initiating impeachment proceedings, or to vote on impeachment. So at that point, it sometimes as some of the examples I pointed out, sometimes it's the court coming in and saving Congress from the president. Well, sometimes it's the Congress coming in and saving the court from the president.
Right.
But it really has to rise to a significant level, I think, before we would see something like that happen, right? Because of those are institutional concerns for members of Congress.
With that, I think I'm going to call time. That's our hour. And now it's your half hour. Time for your comments. I promised you that we would not solve anything tonight, and I don't think we have. We have two interns here with microphones. I know that you all have loud voices that can fill this auditorium except for that one seat in the back corner. So I would appreciate it if you would all use the microphone in addressing questions. Right here. Microphone right there. Okay, you go ahead first, and then we'll go over here.
There's a lot of chatter in the media about a push to convene a new constitutional convention. Please describe what that means, who's involved, and would such a group have the ability to fundamentally alter the basic underpinnings and protections guaranteed by our Constitution today?
I think that's your question.
Everybody's looking at me.
He's our constitutional expert.
I could talk at length about that, but I'll try to hold my comments a little bit here. Article 5 of the Constitution spells out how the document can be amended. And there's basically a two-step process, a kind of national proposal stage and then a state ratification stage. At each one of those steps in the process, there are two different ways of proceeding if you want to amend the Constitution. At the national stage, the way that every amendment up to this point, all 27, have begun is in Congress, by Congress passing a constitutional amendment in that body by a 2/3 vote, and then sending that to the states for ratification, where you need 3/4 of the states to ratify. But Article 5 also has as a way to amend the Constitution the calling of a national convention. If 2/3 of the state legislatures are petition Congress to call such a convention. And that is what this Article 5 convention movement is about. Its focus is on a balanced budget amendment to add that to the Constitution. And right now, I think based on the best estimate, there's about 28 states. I think the most recent thing I've seen with Wisconsin joining in out of the 34 that are needed to call that convention. Now there are some potential concerns with that. First and foremost is that as much as the states calling for that convention may want it to be held to that particular issue, an amendment on a balanced budget, once those members have convened, they're not necessarily beholden to that. Remember, the 1787 Constitutional Convention was convened for the express purpose of amending the Articles of Confederation. And very quickly at the convention, the delegates scrapped that idea and said, let's just start a new document here. So something like that could happen. Now, there are some things that are built in to try to prevent that. States like here in Wisconsin recently, when the legislature passed that, those resolutions put in place requirements that, or put in place the restriction that if members who were from Wisconsin, who were delegates to that convention, if they started to do things other than a balanced budget amendment, that they could be removed. But of course, there's a real question, how will we know what they're doing? The original Constitutional Convention was closed to the public. Would a new one now be open to the public? And other states, there's no guarantee that they would pull their members for doing something similar. There's also the limitation on that, which is, in terms of what could be done, which is that the states ultimately have to ratify it. You need to get 38 states to ratify it. So if it were something that were very much out of line with what we have currently, the states could reject that. But there are a lot of unanswered questions about what could happen at that convention and what that might look like if it did move forward.
Gentleman right there.
In your opinion, which executive orders have had the most far-reaching impact on our nation?
Oh my.
I would say, I think one of them was Truman desegregating the armed forces. That was, I mean, because that was in 1948, I believe.
I think that's right.
And that was quite, so I would say even sort of ahead of his time in some respects. So I think that was very, very influential and consequential executive order.
There have been more than you would realize. A lot of agencies have been created through executive order. Affirmative action got adopted within the federal government, essentially by an executive order from Lyndon Johnson. Peace Corps, I think, was created by executive order. Office of Homeland Security after 9/11, not the department, but the office in the executive branch. So we're just living, I think it's now about half of federal agencies were created by executive action rather than by legislative. It's all over the place.
I'm not one of your experts, but I have an opinion, and I'd say it was the Emancipation Proclamation. That was an executive order in 1862. Mm-hmm. Other questions? Ma'am, right here. I'll get to you next.
So recently, there's been some talk about trying to limit the president's nuclear power, and there's been some chattering in a few of the congressional committees. And I'm wondering, how would that work? Would it be possible, would it have to be a complete law that would be passed and ratified to do that? Because my understanding right now is that, you know, the president has complete nuclear authority. There's nothing that stops him. So how would that work now that we've had this talk about limiting power and things like that? Would it have to be ratified by all the states? Would it have to be added to the Constitution? Where would that go?
Yeah, I mean, I think there you'd be talking about simple legislation as opposed to a constitutional amendment, just in part because if constitutional amendments are really hard to get ratified, but also this would appear to be something more along the lines of when Congress is authorizing a war and using its Article I powers to determine when it might be appropriate to engage in that type of warfare. Now, a president would probably say that that law is unconstitutional, and so you'd have that potential conflict, which might end up in the courts, and then we go back to these questions of are the courts really going to take something like that on? Would they just want to just pass the buck on that? But I think those are the issues you'd be looking at in terms of Congress really taking that type of step, and even ordinary legislation like that. You'd probably have to pass that over the president's veto to begin with, making it very difficult just to pass that.
Yeah, we're going to say the same thing.
So it was his, though. He's going to talk about the War Powers Act probably right now. That was a lot,
Yeah.
and it was completely toothless.
I don't see a way to limit the president's authority in nuclear war or any other kind of war. The Congress has the power to declare war, but if that's the standard, then Vietnam was not a war, and the Iraq War was not a war, and the War on Terror was not a war because those weren't declared by Congress. There have only been 5 in American history that were declared wars. So, and the War Powers Act has been ignored, and the president will always resort to commander-in-chief. So right now, I think there are some delays built into the system. There are some things that have to happen before the launch can happen. There are some codes, and various people have to be in the room together so that things are kind of in congruence on a timeline, and the generals have some involvement. But in the end, the president has to say. And I think something I read recently suggested it might be a matter of maybe 3 or 4 minutes if a president wanted to be quick about it. I don't know how that could be slowed down or stopped, frankly.
Yes, sir. The microphone is coming right to you.
I'm wondering if each of the panelists could share with us their thoughts or their feelings regarding whether the Constitution is a bedrock instrument or whether it's a living document, and whether it's legal or proper or even constitutional for a Supreme Court justice to look to foreign social or legal precedents in interpreting or applying the Constitution.
My short answer is I think it has to live to some degree, because society has changed in such dramatic ways that the founders could not have envisioned. Their thoughts about search and seizure, the role of a militia, the role of the free press, were all within a narrow worldview of what 4 million white property owners on the east coast of North America thought about in the late 1700s. I think it has to be reinterpreted. There's not a pure view on this. One can say we're going to stick literally to what those words meant at the time and apply them today, or one can say we're going to read into it how it might make sense in today's context. I think the truth has got to be somewhere in between, but a strict version that doesn't allow for the world to change, I think would be problematic.
I mean, for instance, the internet. To take your example a little farther, with unreasonable searches and seizures, how in the world would we interpret that literally? Cell phones or the internet. We somehow have to imagine the change in the world in that context. And then the only other thing I would add is they weren't very helpful in being very clear about some of the stuff to begin with. So I'm sure we could set up a whole bunch of people here, and we've already talked about executive power. What does executive power mean? I think that would be very hard to come up with one precise answer. And now we'll go to the expert and see what he has to say.
Well, what I would say is that I think obviously any reasonable interpretation of the document has to begin with the texts and needs to look at the relevant history. And that's, a lot of what we've talked about here this evening as well. There's so much more to that. I mean, obviously questions of how do we know what the original intent was or the original understanding was, just as a matter of the historical record, what's available, what isn't. How do we understand what, did a group of the framers at the convention, they were not of one mind on virtually every issue. There were disagreements. Do we discount what the people who lost on those votes were thinking and so forth? And so there are issues there, but there are issues with any method of constitutional interpretation. And obviously, if you're unmoored completely from the text and the history, that creates its own set of problems. But one thing I might point to here is even Justice Scalia, who was, when he was on the court, was very well known as a textualist and originalist. When he referred to himself as a faint-hearted originalist. Because of the fact that if you go back to the 1780s, some of the punishments that were permitted in terms of flogging and ear cropping and that sort of thing, he openly admitted that those were things that he would find to be unconstitutional because we as a society have changed with respect to how we view what is cruel and unusual punishment. And so, whether it's that living constitutionalist approach or looking at it from a more structural standpoint, even the concept of the separation of powers and federalism, which we consider to be bedrock portions of what the Constitution means, the phrase separation of powers isn't in the document. We pull that together from these specific texts and these specific clauses that we have in there. So I think there's kind of part of a whole package where, the text certainly and originalism in terms of the historical record is important, but that may not answer the question fully for us. And I think that we need to look at and we need to consider other factors when doing that, when interpreting the document.
Here, gentleman in the middle, microphone.
While the mic's coming, I'll just mention I study elections. That's my primary area of interest. The Constitution does not state that there's a right to vote anywhere in the amendments or the original body, so that had to be read in by judges and justices.
I was wondering if you could go into a little bit more detail about the 25th Amendment, if I have it right, about the cabinet being able to remove the president or vote on removing the president, or have we ever seen that happen in our history so far?
No, although the 25th Amendment is not that old. It's only about a half century old in terms of one of the later amendments. But what it tells us is that if the vice president and a majority of the cabinet declare that the president's unable to discharge the duties of office, then the vice president can become acting president. But of course, if the president disagrees, then we have a bit of a problem. And so if the president disagrees, then the president can retake the office. But if the vice president and the cabinet continue to maintain, or a majority of the cabinet continue to maintain their position, then it gets tossed over to Congress. And Congress may then, by a 2/3 vote in each house, state that it's sided with the vice president and the majority of the cabinet. Otherwise, we're back to the president being the president. Now, that's sort of an interesting scenario, though, in terms of considering the Congress checking the president, because of course, the cabinet officials, for us to ever get to Congress, this is the vice president who's the chosen running mate of the president during the election, and a majority of the cabinet who are people selected by the president. So you have to get some of the people who are close to the president, whom the president has selected for their offices, to agree that the president is not fit for the office, which is, for a variety of reasons, unlikely to happen. But if it did happen and there were that conflict, then there would be a role for Congress to play, potentially.
And it's also true that if the majority of the cabinet and the vice president said unfit, and say it was a sickness and there was a coma, okay, then the vice president becomes president. But if the president recovered, he could declare himself president again.
Right, and the president can even declare that there is some sort of inability to exist and turn it over to the vice president at that point. I believe that was, at least during one of President Reagan's surgeries, that it was turned over to Vice President Bush at the time, and there have been other instances of that happening.
Yes, sir.
How dysfunctional would you say Congress is by historical standards? And secondarily, how much blame can reasonably lay at the feet of the current leadership, Mitch McConnell, Paul
Great questions. By historical standards, it's hard to say because the job of Congress has become more difficult over the years. Until a century ago, there was no income tax, for example. So the Congress didn't really have much money to work with. The only taxes were really excise and tariff taxes and sin taxes on things like alcohol. So the Congress is just doing many more things. It's a hard job. When I teach the course on the U.S. Congress to students, I tell them this place is doing a better job than you think, and it's difficult to be a member of Congress. That said, when you have a unified government with decent-sized majorities, so the same party in control of both the White House and the Congress, there ought to be at least a few things on which you agree and ought to be able to move forward. So we talk a lot about the parties being polarized and being far apart from one another, but I think we forget that internally they're also a mess. The Republicans had difficulty settling on a nominee for president last year, in part because there are 4 or 5 factions that are competing for power there. The Democrats, it wasn't quite as obvious because Hillary Clinton was such a front runner, but they also have internal divisions. So I'm very sympathetic to Ryan and McConnell just for the difficult jobs they have to manage their own caucuses, to try to put down the minority that's trying to stop them at every step, and to work with a White House that's somewhat unorthodox and chaotic from day to day. And in the Senate, you've got the filibuster, which essentially stops almost anything where you can't get 60 votes. The majority party never has 60 votes. There was one instance of that during the Obama administration. Before that, I think it was the 1970s when a party had 60 votes. So you're always relying on the goodwill of at least a few members of the minority. Right now, there's no goodwill between the majority and the minority, which is why they're resorting to things like reconciliation as a process to push through. The Affordable Care Act was passed by reconciliation under the Democrats, and the Republicans would like to take that and tax reform back through under reconciliation. But that's sort of cheating. It's using a process that came out of this Budget Act in the 1970s, I mentioned, to make substantive policy. So it's pretty dysfunctional. And even for someone like Ryan, who believes in the Congress and its power, who thinks there ought to be an orderly, deliberative process, that committee hearings ought to be open and committees ought to do their work and there ought to be a timeline for things, he's half succeeded on that. But I don't think he's brought really any bills to the floor that have had amendments offered where the minority could be a part of that process. Missed all the deadlines on the budget. There was no budget, no appropriations bills passed. So it's pretty dysfunctional. I don't know if this is the #1 most dysfunctional Congress. When John Boehner was Speaker at the end of his time during the Obama administration, he said, well, you should stop judging us by how many laws we pass. That's not the standard. And I'm sympathetic to that. He said, you should judge us by how many laws we undo. Because we're trying to undo lots of things that previous administrations done. Even by that standard, it's not fared very well.
Other questions? Yes, sir? Or I can't see. Sir?
The legislature, the Congress, has control of the purse strings. In the balance of power, that seems extraordinary. Very powerful. Are they using it properly in the balance of power struggle, or do they just concede to the executive when it comes to spending money?
I would say they're abdicating their role by not keeping with this traditional budget process. And what that creates is chaos when the fiscal year begins October 1 and there's no budget. There's a stalemate and a crisis where often a short-term so-called continuing resolution gets passed to keep the government open for a week or 5 days or a month or 3 months. This happened all during the Obama administration. I think during his 8 years, there was never a regular budget that was signed into law that ran the government for the next year. And it's happening under the Trump administration as well. So again, when Congress backs away and doesn't do the things that it has the authority to do, it really opens up a space for the presidency to expand and step in and negotiate that directly.
Ma'am? Oh, sir, okay, you first. Go ahead.
Okay. Given all the chaos that you just described, what do you think is the major factor that motivates that or that drives the chaos and the lack of consensus or collaboration?
Others want to weigh in?
Well, I mean, to some extent, well, it's going to be complicated and there's going to be multiple answers because that's usually the way things are in social science. But to some extent, you still have a situation in which members of Congress are trying to position themselves to get elected again. And I think the one other thing that's floating around in here too is there have been, you mentioned that people like to run for re-election by running against their institution, but it seems as though the assault on legitimacy of our institutions is something that, I'm getting old enough to be able to say, I can remember a fair amount of time, but not just saying that Congress isn't really doing its job, but there's just people attacking, even people in office really attacking some of the legitimacy of that institution. And I think that is very poisonous to some extent, because then how do you get into office and then become part of that institution again when you've literally not just said that it's inefficient or, but basically fundamentally sort of corrupt, essentially. I think and then the public, our institutions, the popularity or the legitimacy of our institutions is very, very low all the way around. And I think that all of this is mixed up together, but we're not just saying, well, I'm going to do it better than the other guy. We're saying, well, the other side, they're basically all crooks and should be in jail. It's how do you work with someone that you've said is basically so evil that they shouldn't, that they should be in jail? And I mean that on both sides. I'm not suggesting that one side or the other does this. I think they're both going after each other in really just horrible ways. I don't know what.
I guess I would separate those two things, the polarization problem versus the chaos problem. In an ideal world, polarization could actually be really efficient. If one party was in control and was in full agreement about what it wanted to do, this is sort of like the good and bad of the mafia. Right? The mafia was really efficient at what it needed to do because it was a top-down structure, it was secretive, it was lean and mean, but our parties don't operate that way. The chaos, I think, is a separate issue. The chaos is partly the factions inside the party. For the Republicans, it's the Tea Party and the Freedom Caucus in the House that are giving the leadership so much trouble, the Steve Bannon wing of the party, which is now running challengers against incumbents and trying to unseat them. That's chaotic. And the way that Donald Trump operates as a manager is chaotic. He might admit that. I think that's just his MO as a business person and now as president.
Ma'am?
I think I have the question.
Yep.
That's,
now you got it. Go ahead.
The question that's the elephant in the room that the name of the meeting tonight suggests. Knowing what we know now, do we think that the current occupant of the White House is going to make it through his term? Is he going to be impeached?
Well, the question is, do we know? No, we don't know. Do you have an opinion?
Yeah, the hallmark of good social science is predictive power, I guess. But I think part of the issue is here there are still things that we don't know that would, as far as where the current Mueller-led investigation is going and what's going to be uncovered there. It's, one way of thinking about this is in terms of the way that process is going and slowly and methodically. You think about the Watergate break-in in the summer of 1972, and it wasn't until the summer of 1974 that you were to the point of impeachment proceedings, and President Nixon resigned because of that. And so I think we're at an early stage here where things could go one way, they could go another way, and I think that's too early to tell in terms of that investigation. I think given the current makeup of the House of Representatives, I don't see them initiating impeachment proceedings. I don't see that to be likely without some really earth-shattering change of circumstances, new information. And so I think, at this point, I don't see that we're at a tipping point or anything near that. Does that mean it's not going to happen? I wouldn't say that either, but I think at this point it's just too early to tell where that might go. But again, because of the nature of impeachments, being a political process, it would have to be something very significant for members of the president's party to initiate those proceedings. I mean, again, that was not the case when Bill Clinton was impeached. It was not the case when you were looking at what probably would have been an impeachment for President Nixon, the impeachment of President Johnson in the 1860s. These were all times when the other party controlled Congress, and I think that in and of itself speaks volumes to why, at least at this point, that's unlikely to happen.
Who's got the microphone now? Go ahead.
So I think the answer to my question is pretty straightforward, but maybe you could discuss it a little. If not, I have a second question too.
Okay.
But what do you do with Supreme Court justices appointed by an impeached or maybe improperly elected president?
Constitutional expert?
Nothing, I think, is what the answer is. I think that's the protection of judicial independence in Article 3. President Nixon, and granted he resigned, but had he been impeached and removed, the 4 Supreme Court justices whom he appointed to the court would have kept their seats. Once they're on the court, they're divorced in a sense from what the president does. And so unless a Supreme Court justice were somehow involved in some sort of malfeasance, then that might be a different scenario. But otherwise, simply being appointed by a president who was later impeached and removed, then they're protected in their office on the court.
And you had a follow-up.
Yeah, it's a different question altogether.
It's okay.
What effect does President Trump's persistent attacks on the media or the fourth estate have on the stability of our democracy? How can the other branches of government shore up news reporters' power and influence on democracy without tainting the idea of a free and independent press?
It's a great question, yeah.
So I study media and politics. I think one thing to keep in mind is there have been times, I mean, the press, I don't know, there have been times in our history where you would be shocked at how sort of ugly the press was at that time too, and how people attacked the press. I think that, the yellow journalism, I think that there have been plenty of times in our history where journalism, people did not really respect journalism very much, and somehow, they have come back. So, and then I would say that to some extent, we have a long history of institutions too, and I think that it's very partisan, the kind of attacks that are going on, and that's always been the case for the media. I mean, we have been a society with partisan media from the very beginning. So to some extent, that part of it is not as troublesome to me. The fact that it's difficult for real journalists to get respect, but again, I still think that was always a problem in the era. I mean, the quote I read from the people who wanted to impeach George Washington, that was a partisan press, the side who didn't like him and who were willing to say anything bad about him. So in the whole context of our country, I'm not sure the media is that much worse off than it.
I think I differ. Really? It's because the press has evolved. As you said, there was a time when the press was partisan. Newspapers were actually attached to political parties, and that's not the case. We have a really professional national press corps. You've probably seen this week that the Senate candidate in Alabama, Roy Moore, had accusations made against him that were broken by the Washington Post. It was 4, now 5 women, I think, who accused him of assault when they were teenagers. And what candidate Moore and some of his allies have said is, we're going to sue the Washington Post for saying those untrue things. Now, if those things turn out to be untrue, maybe they have a case. But it strikes me that they're more trying to undermine the credibility of the press. I think it's a real concern. The good news is that high-quality news outlets like the New York Times and the Post and others have seen their subscription rates go through the roof in the last year. I think there are people who are concerned that, a bedrock part of democracy is having a vibrant exchange of facts and having transparency about what's happening And the press is the only outlet to do a lot of that.
Yeah, and although I think, as we talked about here, there are kind of limitations in what Congress might do in reaction to some sort of, if there were some sort of executive action taken beyond public statements. I mean, we have dozens and dozens of cases dating back to the 1930s where the Supreme Court has very closely guarded the freedom of the press. Including, you know, if public officials file lawsuits for libel, and going back to the New York Times versus Sullivan decision in the 1960s, where the Supreme Court was very clear that, you know, even if what is said is false, it is still protected by the First Amendment unless it was said knowingly false or with reckless disregard for whether or not it was false, elevating that standard that you would have to prove in order to collect damages at trial. And above what exists for kind of a private person and what they might have to prove against the press. So when it comes to the press reporting on politicians, on public officials, there's a very high bar there in terms of what they're protected under the First Amendment. And I don't see the Supreme Court backing off of that anytime soon.
And I just want one response. So, you know, I agree that people are undermining the press, but there's a whole school of thought that says if you look at the whole history of the United States, the period of time when we had this, what they actually call sort of the golden age of, I don't know what you want to call it, like the happy media, where there wasn't polarization, there wasn't as much ugliness. That was actually a minority of the history of this country. I mean, that was a small period of time. And so some argue, well, that this is actually the way it was most of the time. Now, that's not to say it's good, so to speak, but perhaps, you know, we will come out of this as we, you know, maybe there'll be another era of good feelings in the media at some point.
This is a little bit off subject, but I'd like your opinion on this. Historically, why was there not putting term limits on the Congress as there was on the president? In this day and age, my understanding is, especially in the House, out of 2 years, you're spending a very large portion of your time just raising money to run for the next time. This seems very inefficient. And is there any push to change this, to go to a 4-year representatives, 3 years term? I mean, what is your opinion on that? Would that make it better? Would we get things more done faster or quicker or easier? Or is it just something that's never going to change?
So in the early days, there were no term limits on the president or the Congress or members of the judiciary. The term limits on the presidency got added after FDR because he had served 3.5 terms before his death in the 4th term. So that's a relatively recent addition. There was an attempt to pass term limits on members of Congress back in the 90s, and the Supreme Court struck that down as a law for being unconstitutional. I want to say about 1/3, maybe 40% of state legislatures have term limits. And I've talked to folks who serve in some of those states. It's not as positive as you might think. Many of them, the term limits are 8 years or 12 years because that lets the cycles work out properly. That means that the Speaker of the House in most of these states has been there 4 years or 6 years, something like that. Very little institutional memory. And as a result, staff have much more power because they've been around. They know how the place operates. Interest groups and lobbyists often have more influence because the legislators are really not knowledgeable and have not been through this. Everything is new for them. In the U.S. Congress, I think the average member in the House now serves about 10 years. So if we were to put in term limits, it probably wouldn't change the experience for most people. It would push out some very senior members, and some of them maybe deserve to be pushed out. I could name them for you. But some of them are high quality, really knowledgeable, experienced legislators we wouldn't want to lose. So I think we ought to think twice before moving too fast on term limits. It's sort of a feel-good solution, but there's so much that it doesn't solve for us.
I mean, expertise has become a bad thing to some extent. I mean, yes, some of them should be pushed out, but there is an area of expertise. You know, people say that about Madison as well, that the institutional memory has dramatically gone down, and that hurts the process because, you know, if everyone's learning everything from the get-go, first of all, no one's there to tell them that they already made that mistake 10 years ago, but we're just so accustomed to thinking if they're there a long time, they're corrupt, but some of them are actually pretty good at what they do.
Yeah, and I would add to the other part of the question, if you're looking at lengthening the terms of House members, for instance, much like if you were to try to term limit members of Congress, that would require a constitutional amendment. You need a constitutional amendment to do that because the Constitution does specify how long the House term is. And especially with the approval rating for Congress as an institution, I don't see there being any public support for lengthening out their terms and giving them more time, kind of looking at it from that perspective. So.
Sir. Yes, you with the mic.
On the day marking the 1 year since the election last year, I heard on the radio that the increase in the Dow Jones Industrial Average for 1 year was the largest in 77 years. Would you give me your 4 reactions to that, please?
First of all, I'll give you mine. I'm not an economist, so I don't know if it's connected to anything political. Go ahead.
I'm not an economist either. I don't feel like I'm qualified to even say what that means, though.
Sorry, not our area.
The Electoral College has created a situation where votes are not equal across the country, both in a percentage of one vote, or how many votes need to be cast before an Electoral College vote counts, and that votes in one state are different than votes in another state. What can be done to get rid of or fix the Electoral College?
Mr. Elections.
Comments?
So there's one really difficult thing and one thing that's easier. The difficult thing is to amend the Constitution and just change it to something else, popular vote, a runoff election. Very difficult to do because of the amendment process. The other thing that I think is more possible and more appealing is something called the National Interstate Popular Vote Compact. It's an agreement that states are entering into. About a dozen states have signed on already. The arrangement is all of us will hold elections for president when the next election rolls around, and whichever candidate wins the popular vote nationwide, all of the states in the compact will agree to give their electoral votes to the winner. If enough states sign on, they control the Electoral College effectively, and it means whoever wins the popular vote becomes president. All you need are enough states to sign on to get to 270 electoral votes, because that's a majority of the 538. Right now, I think it's about 170. There are some big states on board, like California, but you would need some others like Texas and Florida, who probably are not as willing, either because they're swing states and they don't want to give up their power getting all the attention in the campaign, or because they're red states and they think that this system will advantage the Democrats. But that's the possibility. That's sort of a workaround. It leaves the Electoral College sitting in the Constitution, but it says the Electoral College will always be unanimous, essentially, in supporting the popular vote winner.
Do you think, speculate, would the court find that constitutional?
Well, yeah, I think because of the way that Article 2 is written, it's the state legislature of each state that decides how its electors for the Electoral College will be allocated. So I think that would be constitutional. I think there's another
sketchy
issue
part, yes.
There's an issue there, which is, this is kind of the executive order version to the Electoral College being the legislation, in that while it's easier to do this, although it's still pretty difficult, I think, to get 270 Electoral College votes with this interstate compact, it would be easy to undo as well. Like a state could pull out later on, right? Unlike a constitutional amendment.
And they might pull out after the fact, right before the Electoral College meets.
Well, if that were to happen, then it would raise questions that would get into the judiciary, right? Is it a bait and switch sort of thing that's going on with the voters? And so the timing of it could make it relevant to it being struck down. But otherwise, I think it's certainly within state legislatures' power to decide how the Electoral College votes will be allocated, yes.
I can envision some chaos here. I can envision one legislature binds another legislature until it decides to be unbound. They could they could agree now and then 3 elections from now change their mind. Any more questions?
Yes. I think we're rapidly approaching 250 years into what some of the founding fathers referred to as a grand experiment. And the Bill of Rights and the anti-federalist movement was largely motivated by a fear of totalitarian power in an executive branch. And yet, 250 years down the road, we see almost an inevitable creep towards more and more power to the executive branch. My question is, do you see something systemic in our system that if we look another 100 years, 150 years, 250 years down the road, are we going to be in an essentially the totalitarian state that the founding fathers feared most?
I think even though we've been talking about government by executive order and all of the things that the president has done, I think if we asked various presidents about how much power they have, I think they would all be incredibly frustrated and say they can't get anything done. And then of course, then we have executive orders, but we've talked about some of the weaknesses of those. They can be undone so easily. Presidents, and this, you can go all the way back. There's so many great quotes by presidents who feel like, apparently John F. Kennedy was very frustrated because he felt like he couldn't get anything done. And there was some decision on a memorial that they were asking him, will you approve this memorial? And he finally said, yes, I'm gonna approve this. This might be the only thing I get accomplished in 4 years. So I think the view from the president's office is not necessarily that they're quite as powerful. There are still a lot of checks on the president, if not only in his own executive branch, so do I think that in 100 years that we're going to have sort of this totalitarian government? I guess I would say I don't think so.
I have great opinions.
Well, okay, go ahead.
I've read opinions where actually he may be weakening the presidency based on what his actions, as maybe did Nixon weaken the presidency and they basically gave it back to him, or how would you see that position? Just read stuff that was he doing, Congress is stepping up, courts are stepping up and actually denying some of his executive orders, i.e. the transgender in the military, they're basically pushing back. So some opinions are that he may be weakening the president when this is all done and said. I don't know if Nixon weakened the presidency, on your opinion, after his 7 years.
I mean, Trump is definitely running into roadblocks, some of which he created. Some of it is groups who are opposed to his agenda filing suit in federal court. So on the Muslim country travel ban, it's now been stopped, I think, 3 different times and then modified and let go. So so the courts have become the place where the Trump movement has run into some trouble. He's also undermined his own movement a little bit by not appointing people to the executive branch. There are many open positions where having people on the ground could allow the executive branch to do things pretty quietly in an administrative way that right now is just not happening.
I'd like to thank WIPPS, the Wisconsin Academy, and Wisconsin-I for making this possible. Thank you all for your attention and your participation. Good night.
Thank you.